It's now my pleasure to introduce Professor Ernest Young. Professor Young is the Alston and Berg Professor of Law at the Duke University School of Law. He's a 1990 graduate of Dartmouth College. Is there something about going to school in New Hampshire that causes you to explore these issues? He's a 1993 graduate of Harvard Law School. After law school, he clerked for the Honorable Michael Boudin on the First Circuit, and then for Justice David Souter on the Supreme Court, where he joined Professor Gerken. He teaches in the areas of constitutional law, federal courts, and foreign relations law. He is in particular known for his work on the Federalist Revival under Justice Rehnquist. And just speaking personally, is also a wonderful teacher, as is Professor Gerken. I think I'm one of the small handful of people who managed to have them both in the same year as a student. So please, let me add that Professor Sliker has actually done a wonderful job of setting up Professor Young's remarks, which are aimed at sort of really exploring this idea of uncooperative federalism, and for scholars sort of exploring those issues. What are the questions we're going to ask ourselves?
Thanks, Sam. I want to thank the University of Tulsa College of Law and the Tulsa Law Review for having this and inviting me. This is wonderful, but a little bit surreal. And not just because the last time I was in Tulsa, I was 6 years old, and all I remember is eating at the Kips Big Boy. Heather and I don't really see ourselves as being old enough for this sort of thing. But I guess, you know, there's a point to be made that perhaps we are. We have other people's names in our titles, and for have a thing like this. On the other hand, I've just introduced by one of my own students, which is also wonderful, and it's great to see how well Sam is doing in the academy. But it does make one feel like one might be old enough for this sort of thing. The second thing I need to explain is that Professor Gerken is basically my sister. We were co-clerks and office mates with Justice Souter in the 1995 term, and we both understand that the co-clerk bond is absolutely sacred and have always understood that. She's been my best friend for almost 20 years now. But you have to understand how hard that makes it to put her up on this pedestal as a distinguished senior legal scholar. I'll do my best to call her Professor Gerken, and not the stuff we used to call her, like her Heatherness or the Big Pickle. But Heather is probably the best I can do. So I've always already apologized to our honoree for the fact that I'm going to have to recycle a bunch of my standard Heather jokes. In particular, I need to point out an irony. I went on the teaching market a year before Heather, and I went on writing about this federalism thing. And Heather, who had spent most of her schooling and certainly our year at the court immersed in these really important issues of individual rights and gender equality and things like that, just thought that whole federalism thing was nuts. I mean, why do you care about that sort of thing? She said, the only thing that states are good for is to pick flags and birds. And then later on, we had that tiff in South Carolina, and we were down to birds after that. And by the way, I have a project on this, and it turns out states aren't even very good at picking birds, because there's like 7 different states that all pick the mockingbird. I mean, how original is that, right? So Heather was not very into the whole federalism thing, and so it's interesting to see her finally have come around, and wonderful, I think. The other thing you need to know is Heather and I never agreed on anything. Our friendship is not predicated on common views. And so it is nice to see that we find as much common ground as we do in this particular area. I want to talk about uncooperative federalism, which I think is one of the most important projects going on in this literature. Let me give you just a little bit of background on the different ways we've thought about federalism over the course of our history. Most of our history, we thought about federalism in terms of something called dual federalism, which is the idea that you have separate and exclusive spheres of state authority, and never the twain shall meet. So the states regulate education and family law and things like that, and the feds regulate foreign relations and interstate commerce, and the job of the courts in that system is to draw hard and fast rules hard and fast boundaries between the spheres, and then police those boundaries and strike down any act by one government or the other that intrudes into the government sphere. This was basically the law, with complications, until about 1937, when the New Deal revolution swept it all away. After that, we've ended up with a regime of basically concurrent jurisdiction, where there are some enumerated power limits on the federal government. It cannot regulate guns in schools, at least not directly, and apparently 5 people think that it can't make you buy health insurance under the Commerce Clause. It's got to use something else. But basically, those are tiny little enclaves that are left, and the feds can regulate just about everything. But at the same time that the courts stopped limiting the power of the federal government to regulate basically whatever it wanted to regulate, it also stopped limiting the power of the states to regulate basically whatever they wanted to regulate. It lifted the dormant Commerce Clause limitations that had prevented the states from regulating interstate commerce, and so you end up with a world of concurrent jurisdiction, where you largely have different layers of state and federal regulation on many, if not most, subjects. And within that world, we'd have to rethink what federalism means. I mean, I think the easy answer to that question was that federalism doesn't mean anything. It's basically dead. And I think a lot of people in the academy would be content with that. And we've thought about that arrangement in ways. And one way that we've thought about that is in the notion that in that world, once the hard and fast constitutional lines have been removed, we still have political safeguards of federalism. So the protection for the states is not that they have some kind of exclusive jurisdiction, but that they are represented in the federal political process, and more recent versions of that they have state-level political parties that are important to federal political officials. And so these political relationships are what keeps the federal government from using its potentially unlimited power to just wipe out state regulation and state autonomy. The other way we've thought about this relationship, and they're really complementary in many ways, is the notion of cooperative federalism. And so the federal relationship is no longer one of tension, it's one of cooperation. The states exercise a great deal of power, but at the behest of federal officials implementing federal laws. Most federal statutes are implemented by state-level officials. Think about the environmental laws, for instance, where the EPA sets general standards. You can only have so much ozone in the air, but then it requires the states to come up with state implementation plans that may take various policy routes. They may decide to inspect everybody's cars. They may put scrubbers on the power plants. They may lower the speed limit. Lots of different autonomous decisions about how to implement the idea, but they're acting as part of a federal regulatory scheme, and they have roles within that scheme. Now both of these ways of thinking about federalism are really worrisome to most people who care about states, because they just don't seem to offer much in the way of protection. They're descriptions of ways a federalist system can work, but they seem to have gotten rid of the ideas of limits. I don't know anyone who takes all that seriously, the notion that federal representatives in Congress are that eager to protect the interests of the institutional interests of state governments. They may protect the interests of private entities that operate within the states, but the senator is not necessarily looking out for the prerogatives of the governor. And so there's been a lot of unanswered criticism of the pure political safeguards thesis. And cooperative federalism, I think, has struck many of us who care a lot about the autonomy of the states as basically just a nice term for creeping federalization. It's the co-option of the state governments. It's bringing them under the thumb of the man in Washington, and it's just an excuse to have a broader and broader range of federal programs. So I think the incredibly important contribution of both Heather and her co-author, Jessica Bowman-Posen, is to find new safeguards within that creeping world of cooperative federalism within the federal regulatory project, and to argue that actually the role of the state governments in implementing federal law is not just one of co-optation, but also gives them a great deal of leverage vis-a-vis the federal government. And it also shores up the weaknesses in the political safeguards idea, that it's not just the representation of the states in Congress, but it's also the implementory role of state officials, the administrative safeguards of federalism, if you will, that protect the autonomy of the states in the system. they're not the first to have mentioned this idea. Larry Kramer's work, John Nugent's contemporaneous work also explore this idea, but frankly, it's the best. It's the best version of this argument, the most theoretically rich, the most evocative, and the best discussion that's out there. And they're the ones that have pulled this idea out of the skein of other arguments about the way the contemporary federal system works and said, no, this is what we should focus on, this role of the states in implementing federal law. This may be much of the ball game in contemporary federalism, and that is a massively important contribution. So how do state officials resist? And I'm not going to recap the whole article, but just a couple of examples. Sometimes they exploit the discretion that they're allowed within the federal regulatory regime. So Heather and Jessica give the example of Wisconsin and Michigan's welfare reforms which predated the federal welfare reform. The federal statutory scheme actually offered states the opportunity to get waivers from federal requirements and try their own programs, and Wisconsin and Michigan took this and ran with it, and maybe ran with it in directions that the federal authorities did not anticipate. They developed programs that actually challenged the theoretical underpinnings of the federal system that then existed, and that then provided the launching pad for a political movement that ended up reforming the whole system at the federal level. That's not, it doesn't involve breaking the law, for instance. It's exercising the leeway that the federal statutory system did give them, but it's subverted it in an important way. Heather, being a celebrator of dissent, almost seems regretful when the activities of state officials implementing federal law are something that's actually allowed under the federal statutory scheme. She likes it a little better when they're actually breaking the law. And so she gives examples that range all the way to civil disobedience. So you think of situations under the Clean Air Act and Clean Water Act, for instance, when state officials simply drag their feet or refuse to implement various mandates from the EPA. The EPA, under the statutory scheme, has the authority to just kick the state officials out of the business of environmental regulation in that scenario. On the other hand, the EPA also knows that it doesn't have the manpower to kick out any state and take over implementation of the environmental laws. They could probably do 1.5 small states. But if California says, we're not going to do that, so let's talk about what we will do. The EPA really has nothing that they can do. And so civil disobedience can be, I think, a terribly important tool. Heather hasn't heard this story, and I think she may be a little horrified. I actually have a former student who was an aide for a time to Rick Perry, the governor of Texas, and what he was tasked with was to help ghostwrite the Perry book on federalism, which is called Fed Up or something like that. And he calls me up one day as I'm driving from Durham to Washington and says, I know that we've really got to write the governor's book, and that, but I'd like to see if we could maintain some contact between what the governor wants to say and the actual Constitution that you taught me, right? I said, well, okay, that may not be easy, but then we talked about it, and Perry for a time was kind of into things like nullification. And the old South Carolina style, and what I said was, well, what you really need to read is the work by my friend Heather Gerken, because Heather's really written a contemporary justification for nullification. And one thing that she explains is there's lots of ways that you can do nullification that are perfectly constitutional and perfectly legal. So you should really think through this, and maybe you'll get some ideas. So absolutely seminal, the influence of this book.
Oops.
All right. Let me talk about a little bit about where this can go from here, because one quality of the Uncooperative Federalism article is it makes very clear that this is just the beginning of a conversation. Over and over again they say, we're just trying to foreground a particular set of considerations that have been neglected up to now. We're not saying that these are the only considerations, and we're not saying that we have empirical proof that this would work, but we're trying to identify a set of questions for further research. So in that cooperative spirit, I want to offer a research agenda for uncooperative federalists. And I want to talk about 4 areas that I think this work ought to consider, that future scholars ought to explore. One is just the question of what are the actual mechanisms of uncooperative federalism. So Heather gives some case studies in the article, but one thing that becomes very clear very quickly is that it is a very area-by-area question. We have state regulators that are operating in the interstices of federal regulatory schemes, and different federal regulatory schemes are going to give them different degrees of freedom, different kinds of options. Some regulatory schemes have a fixed set of federal requirements, but then there's a waiver regime. Others simply give discretion to state-level regulators, and it needs to start looking at the various ways that these regulatory schemes task state officials and figuring out which of these ways work best and promote the values that we're trying to promote in the best way. I think the second set of questions, and this is something that Heather and Jessica take up a little bit in the article, is are there doctrinal mechanisms in constitutional law that can strengthen this? So there's a discussion in the article of the anti-commandeering doctrine, for instance. Their view is that the anti-commandeering doctrine should be rejected, that you want the federal government to be able to force states to implement federal law, because that way they'll be forced to hang out together. And the more they hang out together, the more uncooperative they'll be, and the more dissent there is in the system, the better. The more bickering, we want to maximize bickering is the doctrine, as far as I can tell. I don't think that's at all clear that that's right. I think it may very well be that the anti-commandeering doctrine, the fact that the federal government cannot actually require states to implement federal law, it has to ask them nicely, it has to bribe them most of the time, that may give the states bargaining leverage. And that's a disagreement that requires a lot of further thought to figure out who's right. Obviously I'm right, but that probably won't emerge until people think about it a lot more. But I think there's also other questions. For instance, one of the things that the healthcare decision really opens up that most people had thought was dead was the idea that there may be constraints on the spending clause. And so the crucial holding in the Medicaid expansion part of the healthcare decision is that at some level, an offer of federal funds by the federal government becomes coercive, and cannot be enforced because it infringes too much on state autonomy. It's a problem with unconstitutional conditions. Now, whether that's good for uncooperative federalism, I think is an interesting question. And one important aspect of that question, I think, is that what the decision seems to emphasize is that the Congress may have to offer partial opt-outs. So the effect of the holding is that just because you took the Medicaid money in the past and signed up for portions of Medicaid, when Congress adds things to the system, it needs to give you a new opportunity to opt out. And so that may allay what I think is Heather's reasonable fear that you don't want states outside the system entirely, because then they can't play as effective a dissenting role. If you have a rule, for instance, that requires multiple assents, so that states can remain in the program but disagree with parts of it, that actually may facilitate uncooperative federalism in a pretty beneficial way. But these are the sorts of questions that I think people ought to be thinking about. Second, what are the wellsprings of state-based dissent? Why do state officials not want to cooperate? One, I think, has to do with them having an independent political base. So part of the problem in the political safeguards literature is it has focused on the role of the political interactions at the federal level. Once people get to Washington, do they impede federal programs and things like that? They haven't really looked at the origins of state politics and the fact that people have a separate political base from the federal government itself. So, for instance, state governors are separately elected, state executive officials are accountable to the governor, or accountable to the legislature, or maybe separately elected themselves. And I think the importance of simply the fact that you are separately elected and beholden to someone else is probably, obviously, one reason for state-based dissent. The second, and this is really in the vein of why don't you cite me more, And one reason you wouldn't cite me more on this is that I haven't finished this article yet and may never finish it.
Finish the article.
Exactly, it's a fair point. But one thing that may drive state policy to be different is that there may be meaningful state political community, there may be meaningful state identity, and big debate in the federalism literature. Do the states adopt separate policies simply because the correlation of forces that we would recognize from national politics is a little different? So in Texas, maybe Republican Democrat is 60-40 rather than 50-50, and maybe in Massachusetts it's the reverse, and that's why they have different policies. If so, that's not quite as interesting. It's important, but it may not be quite as interesting. Or is it because there really is something about being Texan or something about being Oklahoman? I mean, there's going to be a little football game in a couple of weeks in which people dressed in red from one state will strongly identify with this state, and people dressed in orange will strongly identify with the other state, and they will just absolutely hate each other, even though their politics are probably quite similar. So is there something distinctive to states as political communities, and to what extent does that generate different policy preferences, and does that strengthen the impulse to dissent within the implementation of federal law? And if so, if that is important, are there ways to strengthen those senses of identity? All right, so the third question, what about over-cooperative federalism? And I owe that term to my student, Rocio Perez, who was writing a paper for me about Arizona. You can think of what was going on in Arizona as over-cooperative federalism. You have a federal law that's on the books. You have a federal executive branch that is deeply ambivalent about the content of that law and unwilling to enforce it to the max. And you have a state that says, well, pick me, right? I'll enforce it, right? We like this federal policy, and we want to enforce it to the hilt. That is arguably over-cooperative, right? Maybe, if you don't like that example, maybe California in the area of environmental policy is somewhat similar, right? There, California wants to go further in implementing the policy that they think the EPA is for, but just a little bit wimpy about, right? And so the question is this sort of dynamic something good, or is it something bad? And the current tendency in the case law seems to be to treat it as something bad. I think the decision in the United States versus Arizona comes dangerously close. I don't think it goes all the way to suggesting that the enforcement preferences of the executive themselves have some sort of supremacy effect that can preempt contrary state policy. That was certainly the position of the administration, and I don't think the court quite embraces that, but they come dangerously close. I want to suggest that there might be benefits to over-cooperative federalism from a perspective of federal separation of powers. And one of the things that Heather and Jessica point out in their piece is that uncooperative federalism may not just benefit federalism, it may also benefit separation of powers at the federal level. So one of the problems that we have, or one of the puzzles that we have in federal separation of powers law, is the executive enjoys pretty broad authority not to enforce federal law, right? And if it has a different view about the constitutionality of that law, for instance, the Bush signing statements, if it has a different view about the policy of that law, it can decide not to enforce, it can decide not to defend the law when its constitutionality is challenged. Think about the Obama administration's decision not to defend the Defense of Marriage Act. It's not clear what checks there are on this power, right? And it's a power that, if taken too far, could really subvert the separation of powers. Congress is supposed to decide what the law is, and the president is supposed to faithfully execute the law. On the other hand, on some level, I think almost everyone believes that things like prosecutorial discretion is a really terribly important aspect of executive power, and so we celebrate the ability of the executive to kind of stay the hand of enforcement and say, that's not really what Congress had in mind, or that's not really fair, and we're not going to enforce that in that particular instance. What happens when in some areas the exception, the exercise of prosecutorial discretion, becomes the rule? We're not going to enforce that law at all because we think it's terrible or because we think it's unconstitutional. And I think the right answer is probably not to say that's always okay or always not okay. It would be nice if there were some checks, right? I mean, I'm a Federalist 51 person. If there are no checks, I get really, really nervous. And one potential check would be the possibility that if the federal executive decided not to enforce a federal policy, the states could take up that policy and enforce it themselves. Should there be limits on that? Of course. But it may be beneficial to allow states to be over-cooperative in certain instances. So the fourth question I have has to do with fiscal federalism. And fiscal federalism is something I've always avoided like the plague because, there's economics, there's math, there's money, and figuring out how the money works. Political scientists who study federalism often focus straight on the money, right? Lawyers generally don't because it's hard and it's complicated and you have to learn a lot more. And I'm just at the beginning of that project, but I think it's probably terribly, terribly important. One thing you get out of the fiscal federalism literature is that our federal system is almost unique in the world in that the central government does not exercise any control over spending or borrowing by the subunits of the government. That is a very unusual situation. And it has problems that arise, like sometimes the states get in trouble. And right now, they're in trouble. Not only are there massive operating deficits in many states, but there are huge long-term liabilities. You see various statistics on the unfunded pension liability of the states, but it's up in the $3, $4, $5 billion range. So we have a state fiscal crisis. And in those situations, there's a lot of pressure for the federal government to bail the states out. The problem is that bailouts always come with strings, right? And so if the federal government's going to be on the hook for the debts of the states, it's almost certain to try to control the spending and the borrowing of the states. And that would be a significant net decrease in terms of the autonomy of the states to make their own decisions. It would be a radical change in our federal system. So historically, we have had an emphatic and very consistent no bailout guarantee. It is true that Alexander Hamilton got Congress to bail out the states for their Revolutionary War debts, but that was basically the last time. And by 1840, when the states were all up to their eyes in debt again, and then they came to Congress and said, please bail us out, Congress said no, and the states were allowed to fail. They were not too big to fail, they were just big failures. And so they were allowed to default. This is the period in which Dickens wrote his famous line in one of his novels, I forget which, about how something was as worthless as an American security, right? Because the credit of the states went through the floor, and it took decades for them to recover. Again, during Reconstruction, or just after, 9 or 10 southern states failed. Arkansas defaulted during the Depression, and in each of these situations, the federal government did not bail the states out. Now, why am I talking about this with cooperative federalism? The reason is that I think cooperative federalism undermines this no bailout guarantee because the intertwinement of state government and federal government, the essential role that state governments play in the enforcement of federal law, that both cooperative federalists and uncooperative federalists celebrate, does undermine that separateness of fiscal affairs. So, for instance, it just doesn't seem fair to not bail the states out when a lot of federal spending is driving state spending, right? So in a matching program like Medicaid, for instance, even though the match at this particular instance in history is quite generous, it still remains the case that federal increases in spending also require the states to increase their spending. So if state overspending is in some sense driven by federal policy, then it seems unfair to stick the states with the results of that spending. It seems more fair to bail them out. More importantly, I think, the more the federal government comes to depend on the states to enforce federal law, the more the states are not too big to fail, but too intertwined to fail. They're too important a part of the federal governmental apparatus to be allowed to fail, and that creates increased pressure for a bailout. I mean, could you really allow Illinois to fail, to default on its bonds and not be able to carry out its government responsibilities? Because a lot of those governmental responsibilities are federal governmental responsibilities, and a lot of important federal programs would not be enforced or carried out if Illinois is allowed to fail. And so these cooperative arrangements, even if they're uncooperative in the details, create an intertwinement of the levels of government that undermines our system of fiscal federalism. And so I think anybody who wants to put their chips on the notion that the government should be intertwined in this way, needs to think about the money side of it. So I've ended on a cooperative note, an uncooperative note. But I do want to say I'm glad you came around on the federalism. So welcome to the dark side, dear.